All right.
Excellent. Thank you. So hello for today's meeting of the dispute resolution group. It seems that we are a bit a smaller group than last time, but that is still a good attendance compared to what we sometimes had during the on-site events. But the dispute resolution group is always very small compared to the M&A people. Welcome to everybody, and we have today. We will continue with our topic about enforcement around the world, which we believe is interesting for many of us to know how it works if we have a decision. To what extent is it possible to enforce it in other countries? To what extent are there problems? And we have again two presenters today. We have our two countries. We have Omar Puertas and Borja Alvarez from Cuatro Casas in Spain. And afterwards, we will have Ryan, who will present the situation in the US, with certainly a particular focus on his region where Ryan is located at Miller Martin in Atlanta. So if I can ask Omar and Borja to start, and I invite you to all to briefly present yourselves, since you're relatively new to our group here, so it would also be interesting to know a little bit about you, where you're located in Spain, or what is the focus of your practice. So I hand over to you. Thank you.
All right. Thanks a lot, Philip, and thanks to all of you for organizing and welcome us in this subcommittee. So my name is Omar Puertas. I'm a disputes lawyer, disputes partner here in Cuatro Casas. I have worked in Spain, in New York, and in China. I'm back to Spain now. So in China, I have been, by the way, 13 years. So it's an interesting mix of jurisdictions, if you like. And I do disputes, international arbitration, basically. And I am today with Borja Alvarez. He can present himself, and he will. But let me tell you, he's one of our most brilliant senior associates. He will make a great partner in the firm. Borja, present yourself. Now it's easy, right, after this?
Yes, thank you, Omar. Hi to everyone. I'm Borja Alvarez. I am a senior associate at Cuatro Casas, currently based in Barcelona. I have worked also in the Madrid arbitration group, in the international arbitration group. I spent 2 years in New York as well. I'm also a New York admitted attorney, and I do mostly investment arbitration. We have handled several ECT, energy charter treaty cases against Spain. We are also now defending the investors in the annulment proceedings and also seeking enforcement in different jurisdictions. And I also participate in commercial arbitration, international commercial arbitration.
Wonderful. So today, let me share the presentation we have prepared today. I believe you can see that clearly. So we're
yes, we can.
Okay, wonderful. So we're going to speak about enforcement of court decisions and arbitral awards, right? The mix of the court decision is always interesting among in the topic. First, we will be speaking about the legal framework, the avenues for recognition and enforcement in Spain of court decisions and arbitral awards. We will give you a glimpse into some statistics. I must warn you, though, the statistics are homemade, which means that are better than the official ones, if there is any, because we have actually taken the time to go through recent case law. We have read, analyzed each of them, came about with our own conclusions, and we give you just numbers, which is fantastic. And we will be going into more detail in some of the interesting cases. Then we will be looking at a closer look on grounds for refusal of recognition under New York Convention. What is happening in Spain at the moment on this? What parties are claiming for? What kind of grounds are they putting forward to courts? And a final note on enforcement of investment arbitration decisions. Here we will try to be clear as well as brief, because the subject matter could very well be a subject for future presentations in this group, and I just let it there, right? Possible new themes to come about. In terms of the legal framework, when we're talking about foreign arbitration awards, as we know, commercial arbitration awards, we will resort to the New York Convention. Investment arbitrations, if we are at the ICSID level, ICSID investment arbitration proceedings, we will be applying ICSID Convention, where, as you know, there is no exequatur, no recognition of the arbitration award required, while for non-ICSID arbitration proceedings, we will be resorting to the New York Convention. In terms of foreign judgments, this comes a little bit more interesting, if you like. For European Union judgments, Brussels I recast regulation will apply. The Brussels I recast regulation was adopted in the year 2012, replacing the 2001 Brussels I regulation, as I recall. And one of the main issues at the moment was simpler, more straightforward proceeding. In fact, in Brussels I recast regulation, there is no exequatur required between the European Union. We do have then the Lugano Convention that will apply in the case of Switzerland, Sweden, and Iceland. It's similar to Brussels I, the original Brussels I, not the recast. And therefore, that means, among other things, that we will be needing an actual recognition proceeding between Lugano Convention. We have as well the 2005 Hague Convention on choice of court, applicable as well to recognition and enforcement of court decisions. That will apply in the European Union, UK, Singapore, and Mexico, and it has become in effect in the year 2015, actually. So the main, we can go into more detail if you like later on, but the main thing that you would need to remember for this is that in the 2005 Hague Convention, it is applicable as long as there is an exclusive choice of court agreement. That means, for instance, those agreements where typically in the finance industry, where one party needs to bring a case before a judge, before a particular court, while the bank can sue basically anywhere it wants, that would not be valid according to the 2005 convention. And then we have other states. We have first bilateral treaties. We do have bilateral treaties with some countries here in Spain, and failing to that, we will apply the Spanish Act on International Legal Cooperation. Probably the most asked question is reciprocity required in Spain in order to recognize and enforce a foreign judgment? And the answer is no. The principle is no. If you like, later we can go into more detail for this. Avenues for recognition and enforcement of awards and judgments in Spain. Continuing with this framework, if we go into a bit more detail on how to do this, now talking about awards, commercial awards based on the New York Convention, first we need, as we have seen, a recognition. We need to follow a recognition proceeding, the exequatur. This, according to our regulations, will be the competent court will be the Superior Court of Justice, the Tribunal Superior de Justicia. We have one per each autonomous region here in Spain, that is 17 in Spain. The formality is really to bring a lawsuit, a legal claim signed by an attorney and a court agent. The other party has 30 days to oppose, and the prosecutor office will intervene or has the possibility to intervene basically for public order matters. We call it a one-shot process. Why we call it a one-shot process? Because there is no possible challenge against the decision on the exequatur, on the recognition of the arbitration, of the arbitral award, except for a challenge before the Constitutional Court if somehow we can manage to prove that we have not gotten effective protection, and literally translated. So effective protection from the court, I would rather translate by due process, meaning I have an arbitration award that is rendered useless because the court has decided not to recognize the arbitration award here in Spain. So this will be an exception to the exception, and then an exception to that, but it happens sometimes. Then practical insights for you to know, the law doesn't actually say whether the claimant, the company asking, right, the party asking for recognition will have the right to reply to the opposition. It will be in the opposition, as we know, right, where the defendant will oppose public order, what have you, right? So the law doesn't actually give claimant that possibility, but it will be granted in practice. And we will also have a potential hearing. For the arbitration awards rendered in China, Brazil, Bulgaria, Mexico, and Uruguay, we will apply the bilateral treaties that we have with those countries. Is basically a copy and paste, or even just New York Convention directly applicable in terms of opposition to the recognition of the award. And the only thing that will change is the competent court, which will be the court of first instance and not the Superior Court of Justice. Now we have the recognition done in Spain, according to New York Convention. Now the enforcement proceedings will be heard before the court of first instance. And the grounds to oppose will be extremely limited. We have a valid title to enforce, and that will be it. It's very, very limited what we can do against that. The estimated duration, 8 to 12 months for the recognition. Sorry about that. We are extremely, extremely slow here in Spain. And Borja and I were talking about the other day about enforcement, and basically we say 6 to 12 months, but really after COVID, nobody knows. So that is a nightmare. Now, interim measures is interesting for you to know that we do have the possibility to apply for interim measures here in Spain, pending decision on recognition, but also in support of ongoing foreign arbitration and litigation, both. And in terms of statistics, and I have to speed up a little bit. So we have tracked, with the help of Borja and Monica, I believe Monica is around as well, the exequatur decisions rendered by the Spanish Superior Court of Justice, all of them from 2015 to 2021. Out of the 34 reported, 30 decisions admit the recognition of the foreign arbitration award. It's about 90%. And there we have 4 refusals. Well, however, one of them, as we will see, was actually not an award. It was an Ukrainian judgment, and therefore the court basically said, this is not an award, I'm sorry, but I don't know what we are doing here, basically. Similar proportions in previous years, since year 2000. There is, the trend is also similar in connection with foreign judgments. We have about 90–95% of decisions that have been admitted. And the grounds involved invoked in the opposition, as you see, is 15 cases, the majority public policy. Then we have some cases on lack of proper notice, as well as non-binding or setting aside or suspending in primary jurisdiction. And now with a closer look, and Borja give you the floor.
Yes, thank you, Omar. So we wanted to give you to pay a closer look to these 4 cases where recognition was refused in light of our screening of these 7 years of case law in Spain. So what happened in these 4 cases? So first, and this is one case we had the opportunity to handle here at Cuatro Casas, as anticipated by Omar, it wasn't an award. Apparently there was a problem with sworn translation. The claimant tried to persuade the judge that there was only the same word in Ukrainian referred to a sentence or to a judgment and to an award, but it was clear that it was a local court in Kiev specializing in commercial disputes. We didn't see any of the typical background in the award that we typically see, no procedural history, no appointment, we couldn't see if it was an ad hoc or institutional arbitration, and it turned out it worked as a judgment, it spoke as a judgment, and it was indeed a judgment. It was refused recognition for failing to meet the first requirement under the New York Convention. The second one, and I think we have the benefit of having an attorney based in Quebec, Louis Martin. This is interesting. This was a Canadian award issued in Montreal under the UNCITRAL laws. And here, basically, it appeared that the claimant seeking recognition had applied for the recognition in the primary jurisdiction in Quebec. And so the party against whom the recognition was requested said, this is not yet binding under the law of the original forum. And it persuaded the court that under Article 5.1e, the award was not suitable for recognition yet. Here, it appeared that the law, the foreign law here in Spain, was not properly established by any of the parties, but the factum proprium, the own behavior of this claimant who asked for recognition in Quebec was persuasive on the judge. The third one doesn't reflect very well on Spanish judges because it shows perhaps a formalistic approach. This concerns an award issued in London by Quadrant Chambers, this institution, and the attorneys representing the claimant failed to submit to the court the legal reasoning of the award. They submitted the arbitration agreement and the dispositive part, the operative part, but not the legal merits. They tried to amend this mistake to substantiate this at a later stage, but as a matter of Spanish procedural law, the court said this was an essential document that had to be submitted with the first brief filed by the claimant, and they didn't permit the claimant to remedy this at a later stage. So the other party opposed recognition, saying there was a violation of public policy for failure to state legal reasons because the document before the judge actually missed that operative part, and the recognition was denied. The question, perhaps we can discuss this later on, is whether this was without prejudice or with res judicata permitting or if it was permitted for the claimant to submit the full award later on. And the final one, perhaps, is the most controverted. It has been a hot topic in recent months in Spain. It refers to an Ukrainian award where the monetary relief granted by the arbitral tribunal included what was called an exorbitant interest rate of 15% monthly. And even though the defendant did not plead the public policy exception, ex officio, the court granted it. It has been, as I said, a hot topic. We unfortunately, because our court reporting system is not very transparent, we don't know if it has been challenged before the Constitutional Court. We internally believe it's likely that it has been challenged. So we will see if the Constitutional Court overturns this judgment. I'm conscious of the time, so I will these are the bad news. But as we anticipated, there are 30 cases out of in these 7 years where recognition was granted, and generally Spanish courts do not expand the concept of public policy. They don't review the merits. They don't review. They don't think a challenge pending, a challenge against an arbitrator or an expert witness pending in the primary jurisdiction, that mere fact would go against public policy, the recognition of that award. And we must say, and perhaps you've seen this in some specialized media, in recent years, the Spanish Constitutional Court has rendered some decisions, very important, seminal cases, putting in a ring fence the concept of public policy to avoid the annulment of arbitration awards, because there were some bad precedents in set-aside cases. And indeed, Spain received the Global Arbitration Review Award. And just to conclude with this final note, in these times where we are seeing that some ICSID awards are being presented for enforcement in Australia, in the US, and other jurisdictions, we have seen that some of these contracting states under ICSID did not fully follow the mandates of the ICSID Convention and sort of required an exequatur, a recognition of these proceedings. So we wanted to highlight this precedent in Pay Casado v. Chile. It was an investment arbitration case under treaty, under a bid, and Spanish court granted the enforcement without exequatur and issued an order attaching certain assets of the Chilean Republic. Of course, we can assume those which were not subject to immunity from execution of the sovereign state. And we have also some precedents, 3 decisions in particular of the Madrid Superior Court of Justice granting exequatur of commercial arbitration awards rendered against state parties, 2 cases against Guinea, 1 case against the Kingdom of Spain. And basically the courts confirmed that whenever there is an arbitration agreement to submit to arbitration a commercial dispute, then this amounts to a waiver of the immunity of jurisdiction. So that was all we wanted to share with you. Thank you very much.
Thank you very much.
Thank you very much for the presentation. That was very interesting. Are there any questions from the audience?
Can I ask Omar, why are some cases for recognition filed before the Superior Court and some before the Court of First Instance? What's the distinction? What's the reason for the distinction?
You mean for
the countries where there are bilateral investment treaties? So like China, for example, the awards will be filed, I think you said, at the Court of First Instance instead of the Superior Court. So I'm just wondering why the distinction.
Yeah, I believe this comes from originally, actually, the original competent court was the Court of First Instance in all cases, and this changed later on for arbitral awards, but the bilateral treaties didn't change, basically. So this is a legacy from the old times, basically. Yeah. That was changed by the policymaker, and it didn't change in the bilateral treaties. Yeah.
Okay, got it. And I have a question for Borja. You mentioned that Spain has been, subject to a number of investor-state arbitrations. Do you think that has caused a shift in the attitudes of the courts towards enforcement? Because have any of the investors brought the awards to Spain to try to enforce in Spain itself?
No, they haven't, and I don't think they will, because courts of Spain are, of course, are part of the European Union legal order, and we have these precedents of Acmea and now Comstroy against Moldova, and so any Spanish court would need to ask for a preliminary ruling to the European Court of Justice, and enforcement would be denied. So we are actually pursuing enforcement outside of the EU. So we haven't seen any enforcement actions brought here of these cases, and yeah. So we haven't seen any change of attitude.
Thank you. I think you both are right. That could be a topic we can discuss in future sessions, because I mean, in Singapore as well, we're seeing a lot of enforcement of investor state awards, in particular against India. People believe they have a lot of assets in Singapore. So we're handling a number of those enforcement cases as well, arising out of their tax treaties. So yeah, so it'll be quite interesting.
Okay.
I think Francois is.
Yeah.
Yes, thank you. This is Francois Kramer from Luxembourg. Hello, everybody. It was very interesting to hear what you see in Spain. Spain is in Europe. And my question pertains to Regulation 655/2014 on the European Account Preservation Order. And it is stated in section 2.2 of that regulation that it does not apply to arbitration. That would mean, in my humble view, that if you got an arbitral award, you cannot enforce an EPO into other European countries. And I thought that this was quite clear if you read the regulation, but there has been a discussion, and I'm pleading a case presently where the opponents come with expert opinions and say that EPO does apply also to the enforcement of arbitration awards. What does anybody think about this?
For me, it was as clear as for you that it didn't apply. It was one of the subjects explicitly excluded. For me, I don't see. Sometimes we see expert opinions for everything, but this is a very hard one to defend. I don't know.
I send you flowers if you give me a case.
In any case, it's great, Francois, to see you again. It's probably about 4 or 5 years that we have not seen your face in our group. So it's great to see you back.
I'm very sorry, and I must apologize, but I've been the bâtonnier in Luxembourg, and I'm the past bâtonnier, and this has taken up all of my time, but I will be coming back, and I'm back.
Wonderful. And also hello to Yes, which is also one of our participants since I'm participating, which is also already quite a few years now. So I have one additional question to our Spanish colleagues. You mentioned that the prosecutor could intervene, which is something which would not exist in Switzerland. So what is the role of the prosecutor here?
Yeah, actually, the role of the prosecutor is not very detailed, if you like, in the regulation itself. What it will basically be concerned about is matters of public policy, corruption, things like this. So, for instance, if as we have had in some countries, if you may be concerned that an arbitration award is actually the purpose of the arbitration award is money laundering instead of really seeking justice. So that might be the kind of topics that the public prosecutor may be concerned with, basically. Yeah.
Okay. The court could not address this by itself, because
yes,
I've seen that in other countries, exactly this question, that the court addressed that by himself.
No, the court can do that as well in Spain.
Okay. Okay.
Yeah. For instance, the case that Borja explained about the 15% interest monthly. That was quite something really for the parties to agree, if you ask me. But so, no, I mean, the defendant didn't oppose anything related to that, to the 15%. And it was the judge himself who thought, I don't think this is quite right. which is unbelievable. But and it was the court itself, the judge itself who brought about this in order to oppose, to deny enforcement recognition.
Okay.
Yeah.
Yeah, it seems very high, but I don't know whether they have such a kind of currency which loses so much value that it can be a reason.
Exactly.
Because otherwise, I think Swiss courts, they would also start to look at that.
Yeah.
Excellent. Any further questions?
Perhaps one last point, Borja, if you ever have any issue with your partnership admission, I want to point out that Omar's introductory remarks were recorded this morning.
I'm glad this has been recorded. Thank you.
Well, then I would ask Ryan to do the presentation about the US. And as you are probably aware, the idea is to continue with this, and any volunteers for the countries are welcome to reach out to the co-chairs. Ryan.
Thanks, Philip. So my name is Ryan Kurtz. I'm with Miller & Martin in Atlanta. I am a litigator and do also a fair amount of arbitration work, primarily in the areas of in the area of commercial arbitration. Let me see if I can pull up this. See. Bear with me one second. All right, so I'm going to talk, as Omar and Bohar did, about arbitral awards and foreign judgments quickly. I think the language of the New York Convention has a number of exceptions to enforcement. They include issues such as violation of public policy, incapacity, invalidity under the laws of the governing state. I think, generally speaking, most of you in the audience are going to be familiar with these exceptions to enforcement. I'm going to focus primarily on the issue of public policy exception. Don, do you know if is this showing? All right, excuse me. All right, so with respect to public policy, this is a very, very tough argument to prevail on in the United States. The U.S. has a very strong federal policy in favor of arbitration and arbitration dispute resolution. It's been recognized for many years as having special force in the field of international commerce. So in order to justify a denial of enforcement based on a violation of public policy, you really have to show something special. As some of our courts have said, it must violate the forum state's most basic notions of morality and justice. Generally speaking, the courts are going to look at national policy and not on a state-by-state basis to try to come up with some consistency from a sort of a national perspective. One issue that comes up that we'll touch on is the fact that an award which merely violates U.S. law has been recognized almost universally in the U.S. as not being sufficient to establish a public policy exception. So simply because the arbitrator, may have come to a conclusion that might be inconsistent with U.S. law does not mean that a U.S. court is not going to recognize that arbitral award under the New York Convention. It's also, there are a number of cases recognizing that the erroneous legal reasoning or even the misapplication of law is typically not a violation of public policy under the convention. This is an argument that's raised quite often in the U.S. and is rarely successful. A few examples of awards which did not violate public policy. One of which was a fairly recent decision from our Fifth Circuit Federal Court of Appeals in 2020, where the tribunal essentially rejected an argument that the contract was procured through bribery. We're going to come back to that case in a couple of minutes. Other exceptions include a situation where the tribunal awarded attorney's fees to a defendant, even though the applicable federal statute did not allow for the recovery of such fees for that party. The court in Oregon, the federal court in Oregon, said that was not a violation of U.S. public policy. And then finally, where a tribunal found that the losing party was jointly liable, even though the signed and underlying arbitration agreement, he signed the agreement in his representative capacity and was found to be a liable party, did not violate U.S. public policy. There's a fairly interesting recent decision involving Carnival Corporation that shows, I think, a trend towards an even more narrow interpretation of the public policy exception. I think I would say years ago, the courts seemed to be a bit more receptive to arguments, public policy arguments, in which a movement could show that an award denied him or her a right under a U.S. statute. Recently, the courts have been less inclined to set aside such awards, even upon such a showing. And that's exactly what the 11th Circuit Court of Appeals held in the 2019 case of Pavoro versus Carnival Corporation. In that case, the court refused to set aside an award in which the arbitrator dismissed the claimant's claims under a U.S. federal statute applicable to seafarers and applied Panamanian law. The court found that the U.S. had a clear and defined public policy in favor of protecting maritime workers from the unscrupulous actions of their employers. But despite the court recognizing this public policy, the court found that the remedies available under applicable law, which in this case was the law of Panama, were not so inadequate as to violate the U.S.'s most basic notions of morality and justice, even if it did violate the U.S. statutory law. So the court found that the tribunal's refusal to apply U.S. law did not violate U.S. public policy. One of the, I think, clear lessons from the Carnival case is that as long as the applicable law provides some remedy to the claimant, the court is likely going to enforce that award in the United States. If on the other hand, if you had a situation where a movement could show the court that the law applied by the the arbitrator did not allow any sort of remedy, then you may have a different result, but those cases are very, very rare. Another noteworthy case, fairly recent, is the case of Hardy versus the government of India. This is a case from 2018. It was decided by the federal court in the District of Columbia. This case involved an arbitration that included the government of India and the Ministry of Petroleum and Natural Gas. The tribunal actually made an award in favor of Hardy of specific performance. And this case is, I think, fairly limited to its facts, but the dispute related to the extraction of oil and gas from India. And Hardy was awarded a contract to explore this geographic area in India, and to, if it identified hydrocarbons for extraction, it would then have a certain period of time to make a declaration as to whether those hydrocarbons were could be commercialized or not. The parties got into a dispute. The Indian government essentially terminated the contract and declared that Hardy's time for commercializing or declaring the commercialization of certain hydrocarbons that Hardy had discovered had ended. Hardy initiated an arbitration proceeding, and the arbitration panel in that case found in favor of Hardy and essentially ordered the Indian government to allow Hardy access to the geographic area for the purpose of determining within the years remaining under the contract whether it intended to commercialize these particular hydrocarbons. When the enforcement proceeding was brought in the District of Columbia, the court was faced with a public policy argument by the Indian government. And in a fairly long and interesting opinion, the court refused to enforce the specific performance part of the award. In other words, the part of the award that required the Indian government to allow Hardy access to the geographic area as was required by the contract. The court found that enforcing that part of the award would violate U.S. public policy interest in respecting the rights of other nations to control the extraction of natural resources within their own borders. Again, I think this is a unique case. It involved obviously a state party, and as I've already mentioned, involved the extraction of natural resources within India. The final case I want to briefly mention is the Vantage Deepwater versus Petrobras case. This is a 2020 case decided by our Fifth Circuit Court of Appeals and another federal circuit court of appeals here in the U.S. This case was not actually a New York Convention case. It was a Panama Convention case, but it involved a public policy argument that is I think would be treated similarly under the New York Convention. In this case, one of the parties alleged that the arbitration agreement at issue, which involved the establishment of an oil rig offshore at drilling to be used for oil and gas extraction, was procured by bribery. And I will say, if you look at the facts of this case, there were prosecutions in Brazil, not necessarily directly related to this contract, but involving some of the interested parties in which bribery was clearly established. But the arbitral tribunal found in this case that Vantage did not prove bribery related to this contract, and perhaps more importantly, that the parties ratified the contract at issue. In other words, the bribery issue came up very early. The parties continued to operate under the agreement for many years, and then only after Vantage was dissatisfied with the arbitration result that it raised this issue. The issue was raised in the form of a public policy challenge. The court clearly found that this public policy question cannot be used to effectively question the merits of the award. The court importantly also found that the validity of the contract, in other words, whether it had been procured by corruption or bribery, was ultimately a question for the arbitrators, that the arbitrators entertained that issue, considered that issue, and rejected it. And the court was not going to essentially second guess the arbitrators with respect to that decision. With respect, I'm going to move quickly on to foreign court judgments, because I think this is probably a little bit more unique to the US. Interestingly, despite the fact that we have various conventions related to arbitration awards, the US generally doesn't have any treaties related to the enforcement of foreign court judgments. So how is it done? It's really done under sort of two frameworks. One is what we'll call federal common law, and this is common law that's been developed beginning in the late 1800s with the Supreme Court decision in Hilton, which was decided in 1895. There are a number of factors that the Hilton case established for enforcement of foreign court judgments, and that have been largely followed by the courts since Hilton was decided. Those factors include the full and fair trial rendered by a competent court, due notice to the defendant. These are generally what we would call due process requirements. A fair and impartial judicial system, lack of prejudice or fraud in the proceedings, and then finally the reciprocity issue, which is, I would say, of questionable significance under today's jurisprudence. The reciprocity requirement has, I think, slowly eroded over the years and fallen out of favor with the courts. And I think part of that is as a practical issue is that it's not really a black or white issue. I mean, I think it's very difficult for a U.S. court to determine whether the courts in Colombia, for example, or Indonesia would or would not similarly recognize a U.S. court judgment. And so what we're seeing now is that most of the courts are sort of looking at reciprocity as a less important factor and handling it on a case-by-case basis. Because as you can imagine, there may be certain facts under which a U.S. court may not recognize a foreign judgment. But that doesn't mean that they would never, for example, recognize a foreign judgment from certain countries. With respect to, let's say, one of the trends that's emerging in this area, I want to mention briefly China. I think really since approximately 2009, you've seen a number of U.S. courts begin to recognize foreign judgments coming from China and vice versa. I understand that there are Chinese courts that are now recognizing U.S. Judgments. Finally, I want to mention the other, let's say, framework in addition to the federal common law, which we've just discussed. There is a lesser used statutory framework in the U.S. that applies that's been adopted by approximately 32 states within the U.S. that applies. It's called the Uniform Foreign Money Judgments Recognition Act. It only applies to money judgments. It was enacted in 1962. I think it largely tracks the requirements of federal common law that we just discussed, but it does have a few additional limitations. For example, as I just mentioned, it only applies to monetary judgments that do not include taxes, fines, or other domestic support. And it has like some of the exceptions we've just talked about. There are a number of grounds for non-recognition, but they're going to be very generally, limited and very rarely accepted by the courts. And with that, I am finished. Thank you very much.
Thank you. I'm just looking at the clock. It's already about 3 minutes to 4. Louis Martin, I think in the favor of allowing a few questions, if you don't mind, I would suggest that postpone the presentation of the Davis team to the next meeting, which is already scheduled.
Yeah, no problem at all.
Okay, sorry for that. Ryan, I have one question. I think I've heard at some time, but maybe it's completely wrong, that when you want to enforce a foreign court decision in the US, that there is a time limit for doing that, which might be lower than the kind of the statute of limitation and the law of the country where the decision is rendered. Is that correct, or is that a complete misinformation which I heard?
Yeah, Philip, I'm not sure. I mean, obviously there's a clearly defined time limit for for domesticating or enforcing arbitral awards under the New York Convention. I would assume there's a similar time limit for the enforcement of foreign judgments, but I can't say that I know exactly what that is. And I guess the other question is, does it depend on the jurisdiction from which the judgment is coming from? I just don't know that.
Okay. Any other questions from the audience?
When is the next meeting?
Hannah, I don't have the date now before me. Do you know it?
Sure. The next meeting is Monday, November 15th at the same time, which I do think we're going through some time changes before then. So it's 9 a.m. Eastern New York time. So however that adjusts for you all, I'm not 100% sure, but I do know end of October, beginning of November is when we typically go through daylight savings adjustments.
Yeah, it's always end of October, beginning of November. Do have to be very careful since
that's right.
Exactly at the same point of time in Europe. It's the last weekend of October. In the US, I think it's the first weekend of November and November. Exactly, and so that that's always, you have to but today with the internet, you can always enter that into the internet and then to find out what time
That's
is.
right.
Okay, so it's exactly 4 o'clock. So I think we have completed the hour. Nevertheless, I maybe 2 minutes more or so. There are a number of new faces here, and maybe if you could just very briefly say hello and where you're located and what your main focus is.
I think we do some. I know, Mike, you're new to us. I don't think we've seen you here previously.
No, good evening, everyone from Western Australia. It's nice to meet you all. I know some of you, Peter Burt, for example, already. I've worked with Francois Kramer a long time ago in the past when I worked in England. I head the Perth dispute resolution team from Inter Ellison, mixture of litigation and arbitration. I used to be a chair of the International Bar Association's litigation committee. And just at the moment, my life is dominated by a Royal Commission up in Papua New Guinea, which we're doing remotely. So that's keeping a lot of us busy down here. But it was fun to take part in this. And subject to the time changes, I look forward to taking part in the next one too.
Great.
Thanks, Mike.
And then I think also
Peter.
Yes, hello. I used to come to live World Law Group meetings about 10 or 12 years ago, until it became too much to go both to the IBA and the World Law Group, and I had to make a choice, which was a difficult one. I'm based in the Frankfurt office. I have a broad disputes practice comprising mainly corporate litigation and arbitration. And once in a while, I try to spread the news about German dispute matters in an English language blog.
Great.
Well, welcome
Great
back,
to have
Peter.
you back. And then I think Robert and James. I think you're on mute.
Yeah, hi. I'm actually in Spain at the moment, but I do a mix, exactly. Nicer weather down here. So I do a mix of corporate work and some litigation, and I've in the past done quite a lot of arbitration work.
Robert, let's meet.
If you're in Marbella, we can meet.
Marbella, oh, great.
Oh, it's a good excuse, actually.
Very good excuse.
Good morning and good afternoon. I'm James Wagner. I'm an associate in the litigation and arbitration team in the London office of Faegre. I very much enjoyed all your presentations and your wonderful backgrounds as well.
Okay, great.
I must admit that I borrowed my background from Philip's home country. You're looking from the Austrian border, you're looking out into the Swiss Alps.
Very nice indeed. It beats London, that's for sure.
Yeah, and it beats Germany in terms of height as well, yeah.
Well, but it's true that we tend to make jokes because the Germans, they don't have a peak which reaches 3,000 meters, but they have to admit that the mountains in the south of Germany around Zugspitze, they're really impressive because it's first they're very rocky, and second the countryside around them is relatively lower, and so it's nevertheless very impressive and nice over there. Okay, so great to have you had everybody here, and I hope you will join the next time and again. And as I have mentioned, we are happy for volunteers. Otherwise, I will reach out to you for two new countries to address the topics which have today been presented perfectly by our colleagues from Cuatro Casas in Spain. Thank you, Omar and Borja. and by Ryan for the US. Thank you also very much to Ryan. So next time, 2 new countries, please, for these presentations. And in addition, we make sure that we will have then the introduction to the dispute resolution team of Davis in Canada. Sorry, Louis Martin, that we have to postpone that, and looking forward to have that presentation the next time. Thank you much, and to everybody a great day, good night, whatever your time zone is. Thank you for participating.
Thank
Thank
you.
you all. Have a great day.
Thank you all.
Thanks, everyone. Bye.
Bye.